And just real quick, I just wanted to introduce Cassie Bueller as a new law student intern here at Legal Rights Center that's going to be helping me out. So is joining us today.
Welcome.
Hi, everybody. Thanks for having me.
Okay, so we're recording, we've got it all set. We'll need to do a roll call to establish quorum. Mr. Vogel, would you just mind doing a roll call?
Certainly, Madam Chair. Ms. Dawson?
Present.
Mr. Esme?
Present.
Ms. Evans? Ms. Evans? Mr. Tatum?
Present.
Ms. Williamson? Ms. Williamson? All right, Madam Chair, 3 members are present. A quorum is present.
All right, perfect. Then just our first, before we get into our main topics for today, is that a copy of the January 10th meeting minutes have been posted to the task force website. So if anybody's had a chance to review them, if there are any corrections, please let me know. Hearing none, then with no objections, the meeting minutes are approved. So first topic for today is Mr. Vogel's going to give us just a little update. He's still doing more research, but he is going to give us an update as to his research. And then we do have Katie Ryan from DHS present. So thank you, Ms. Ryan. And she'll be giving us a presentation on the reconsideration process, which I know all of us have thought would be very helpful. So Mr. Vogel, I'll turn it over to you.
Thank you, Madam Chair. So yeah, as an update on my research, I guess I'll need to lead with a little bit of an apology that I only have some information on 2 states for you today. It's been a very hectic 2 weeks. But I am prepared to briefly compare Wisconsin and Iowa and how their statutes how their statutes equivalent to 245C appear to work, and that actually dovetails with one of 2 other updates I wanted to give you. An update / a request for thoughts on my research strategy. So offline, I know I've had some discussion with Chair Dawson and some other members about a research strategy focusing on Midwestern states specifically as most comparable to Minnesota, which is why I focused on Wisconsin and Iowa. And to further refine that, I've had some suggestions from members to focus specifically on essentially Midwestern states that are socially, politically comparable to Minnesota. So Wisconsin, Iowa, Illinois, Ohio, Pennsylvania, if you want to count it as a Midwestern state. I know I personally don't, but sort of similar to Minnesota compared to states like Texas, California, or even necessarily the Dakotas. So your thoughts on that, just let me know which way you'd want me to go, if you want me to go some other way. But I think that's where, if that's okay with you, it makes the most sense for me to focus my research efforts going forward on states like Ohio, for instance. The other update I want to give you is on my parallel research on the preponderance of evidence standard. I'm working with the legislative library on that, but it's been a little bit of slow going. We hope to have a comprehensive view completed by next week, but unfortunately, I can't give you a comprehensive view of that right now. I will give you updates as I get that. So thanks for your patience. So just briefly, and feel free to interrupt me at any time with questions, comments, that sort of thing. So
just quick talk about this. That's the strategy question.
Oh, absolutely.
Because I guess I would be curious to see at least what the Dakotas are doing. They are so close in proximity, and even though they might be a little bit different politically, I think frankly, there are big chunks of Minnesota that are politically similar. We're pretty purple state. So I kind of think it would be helpful as we sort of move forward to maybe at least see what they're doing. Maybe, I don't know that I agree with sort of the general strategy of focusing on Midwest states. And I'm not trying to put a ton more work on your plate, but and other sort of policy areas, I do think that looking to see what the Dakotas are doing is sometimes sort of persuasive and of interest to our state legislators. So
yeah. And Mr. Esme, I can also jump in. I do also have a law clerk who has agreed to help do research on other states too. So Mr. Vogel is going to be focusing on, and Mr. Vogel, if you can, at the Dakotas, that would be great. But then we'll at least try to get some other broad information on the other states, hopefully in kind of a table form, so it's easy to also look and compare to.
that'd be great. And I think at the risk of volunteering here, I think Ms. Bueller would be happy to help with that effort as well. So maybe at some point later on this week, the three of us could connect and game plan how we can help. We'll get that done.
Perfect.
Thank you, Madam Chair, Ms. Esme. Madam Chair, Mr. Esme, apologies. Yes, okay, I'll incorporate the Dakotas into my research going forward. Yes, and let me know if you'd like me to help facilitate that meeting, or if you'll just handle that on your end. So briefly then, touching on Wisconsin and Iowa. Wisconsin. Sorry, I'm trying to collect myself here now. So Wisconsin's relevant statutes would be Wisconsin Code 48-685 and Wisconsin Code 50-065. I can provide copies of those to the members if you'd like. I'll do that after I complete this. And essentially what, if I'm reading the Wisconsin statutes correctly, sorry, I'm trying to share my screen here. If I'm reading the Wisconsin statutes correctly, they do disallow a caregiver license to subjects who have been convicted of a certain list of crimes. So here on my screen, I'm sharing a informational document put out by the Wisconsin Department of Health listing those crimes. It's the same list that can be found in their statute, just a slightly easier read. So here we have a list of convictions that disallow serving in positions serving people over 18 years of age. And it's a slightly longer list of convictions for serving people under 18 years of age. However, the statute does then provide for their Department of Health Services, I believe, to evaluate applicants for evidence of rehabilitation. Specifically, the statute in section 50-065 specifies a clear and convincing evidence standard of rehabilitation that the department would use. And if I'm reading this statute correctly, therefore, there is no permanent bar to employment under Wisconsin law. There are these permanent disqualifications, but there then is a means by which an applicant can demonstrate their rehabilitation to the satisfaction of the Wisconsin department. Moving to Iowa, Iowa Code 135C, Section 33 is the relevant statute for caregivers in positions like nursing homes or that sort of thing. And I do want to apologize that was what I based my statement that Iowa appears to give discretion about what crimes constitute a risk of harm to their Department of Human Services. That statement was based on that statute, which, if I'm reading it correctly, does say that. I want to highlight, however, Iowa statute 237.8, which governs child fostering. And there it's broadly similar. Again, their Department of Human Services conducts a background check and a risk of harm evaluation when they found a conviction for a crime. But this statute specifies a narrow band of crimes, conviction for which appear to be a permanent bar. So or a 5-year bar in the case of a drug-related offense. So child endangerment, domestic abuse, crime against a child, a forcible felony, that'd be the list there. So so as a really broad takeaway from all this, it appears that both Iowa and Wisconsin have less expansive lists of bars to or even permanent disqualifications than Minnesota does. Iowa has this narrow band of bars specifically for child fostering. Wisconsin has a mechanism for rehabilitation to be demonstrated in the case of all of these statutorily listed crimes. And the Wisconsin list of disqualifications, for example, are some, frankly, pretty heinous crimes, but a smaller list than Minnesota's 245C15. 245C15, for example, lists kidnapping and drive-by shooting as permanent disqualifications, which then in turn that triggers the permanent bar. Those aren't at a glance crimes that are on this Wisconsin list. My second takeaway.
Will, I'm sorry, Will. Can I just
absolutely.
I'm not actually seeing. Did you see like the sort of the honesty crimes like thefts and frauds and stuff on either of these?
Mr. Esme, just a moment. Let me pull up my notes here. I don't believe so. Okay. That's actually something I'll want to go back and check. The Wisconsin statute simply lists crimes by their statutory number, so I'll need to. And I cross-checked with this document, which were all these violent crimes. I'll want to go back and make sure there isn't a list of crimes of honesty.
Okay, thank you.
Yeah, but there weren't crimes of honesty listed in the section that I interpreted as a permanent disqualification. The language was essentially disallowing someone from serving in a position if they've been found to commit these crimes, unless they receive this finding of rehabilitation. So yeah, I'll definitely make sure to do that. Oh, and anyway, so that'd be my first takeaway, that these appear to be more narrowly focused, if I could put it that way, lists of disqualifying crimes. My second takeaway would be that these appear to involve a higher evidentiary bar than Minnesota's preponderance of evidence standard. Just to repeat the magic word again, these are all convictions, with the exception of findings of abuse or neglect. And the findings, if I'm reading the statutes correctly, would be findings previously made that are on a background check. They wouldn't be findings made by the relevant department at the time. Similarly, even this Iowa statute on family fostering or child fostering, lists convictions for these crimes. So I'm interpreting a conviction as involving a beyond the reasonable doubt evidentiary standard, which, as you well know, is a much higher evidentiary standard than a preponderance of evidence standard. So that I think is interesting and something worth highlighting. So yeah, apologies again that this is a fairly short presentation. I can definitely check on that issue of crimes of dishonesty, Mr. Esme, and I'll send out copies of these statutes to the members. And the space for any other questions or directions you'd like me to look into.
May I ask another clarifying question?
Please.
So it sounded like the Wisconsin statute you were looking at, if I'm remembering right, had sort of permanent disqualifications, but you determined that there wasn't a permanent bar because there was a mechanism for the state to find by clear and convincing evidence that they had been rehabilitated, right?
Yes.
And
in
was
fact,
that?
I'm just going to share my screen and put it up here. So sorry. So please continue your question.
I was just on. So I thought I understood that clearly for Wisconsin, but I was less sure about what you found in the two Iowa statutes you were looking at.
The Iowa statutes empower their Department of Human Services to make a determination of risk of harm, and they say that their Department of Human Services shall make its own regulations for how they make that determination. If you'd like, that's something I could hone in further on and try to get a copy of those regulations.
Yeah, that would be good. It sounds like the rulemaking is just at the agency level, not the statutory level there.
Yep.
Okay. Thanks, Will.
Yeah, definitely. And thank you for your
Yeah, thank
question.
you.
All right. Gonna stop sharing here.
Question, Will, I was wondering about the, excuse me, like you said, the convictions, right? They focus mainly on convicted, not the ponderance of evidence. Is that correct?
Yes, Mr. Tatum, that appears to be so.
Okay, yeah, that's very interesting though. Like, so is that, like you said, we're like, overall, like, but there's no guarantees. But they let you know that they'll focus on that, won't go outside of, well, we see this here and you have not been convicted. And so basically, like basically I'm just going in a circle, but basically what you're saying is just focused on the act itself and not what other things are saying in the paperwork.
Mr. Tatum, yes. Yeah, I should note that my understanding is, under Minnesota's system 245C, the department still makes a determination based on an act itself. And sorry, I realize I'm speaking for DHS when I shouldn't be. We have Katie Ryan here, but it's just with the lower evidentiary standard, preponderance of evidence. Sorry, Ms. Ryan will presumably go over all this, but it's just my understanding is that it takes less for the department to find that you did it, whereas with a conviction, it takes a lot for a court to decide that.
Yeah, that's very important though, because if you really look at it, because some people might have crimes that were certain crimes and got switched to another charge. You get what I'm saying? But at the same time, you might not be convicted of that, but this still might be in your paperwork for some reason.
Mr. Tatum, that's a fantastic point and question, and I'm going to be quiet now and defer to Ms. Ryan, and I'm sure she'll have a lot more knowledgeable stuff to say about that than I would. But that does seem like an incisive point.
And I think, if everyone's all right, maybe it makes sense if we could hear from Ms. Ryan at this point, and then of course there can be questions after that. So Ms. Ryan, thank you so much for agreeing to come here today and to give us your thoughts and to help educate all of us. I know we very much appreciate it. So with that, I'll turn it over to you.
Thank you for the invitation to join you this morning. I think we do have a presentation and we're about to share the screen here. Let me just see if we've got the screen up. I'll say while we're getting the screen up that it looks like this group might only be expecting a presentation on the reconsideration process, but we actually took the ask to more broadly be asking for a deeper dive into a variety of discretionary decisions that DHS looks into. So we are prepared to discuss the POE process, reconsiderations, and expungements, and that would be great, Will. Thank you.
I think that's what we were looking for, Ms. Ryan. Thank you.
Okay, great. Hope this covers what you were asking for. And Mr. Vogel, I think is going to help me out. I don't have the technical skills to share my screen, so thank you so much.
Yeah, apologies. I have a copy of Ms. Ryan's presentation on my end, and I'm just retrieving it from the depths of my folders to share my screen. So apologies. Thanks.
Thank you, Mr. Vogel. Okay, so today we'll look into a variety of discretionary decisions that are done by DHS under the authority of 245C. And let's go to the next slide here. The first area that we're going to look into is actually who can work while the study is processing, because there is some discretion that's afforded in that process. First of all, a study has to be affiliated with a program. And for most types of programs, 245C generally does allow the study subject to work while that study is processing. So for example, I've listed a whole, I've listed kind of a snapshot of those program types. Basically, most programs that are licensed by DHS or MDH are allowing study subjects to work while that study is processing. In certain cases, in a very limited number of cases, supervision might be ordered. And so that would be, the subject would be required to be within sight or hearing at all times of a person who is cleared to study. We'll talk more about that in the next slide. There are some programs that, oh, sorry, not yet, Joe. Well, just one other note here, that 245C does prohibit certain subjects for certain programs from working before they receive their clearance or their set aside. So examples here would be personal care provider organizations, that would be like for PCA services, and special transportation services. Those are certified by the Department of Transportation, and then childcare, which has some federal requirements. Next slide. Well, thank you. So in terms of who can work while the study is processing, if a study is not completed right away, DHS is required to give notice that more time is needed to complete the study. And in that notice, information about whether the subject can work without supervision or whether the subject is required to be supervised at all times is required to be part of that notice. And so there's a list of risk of harm factors in another part of 245C, which is 16. That's the disqualification factors, risk of harm factors. And DHS uses that list to determine whether or not supervision should be ordered during the time that the study is processing. Then in the disqualification, DHS has options. Again, work without supervision while the reconsideration period is active, or work with supervision, or immediate removal. And I give you that site there. Next. Another area where DHS has some discretion is in disqualifications based on maltreatment. So I want to distinguish the substantiation of maltreatment itself from the disqualification based on maltreatment. DHS reviews information about substantiated maltreatment from counties and also from DHS and MDH. The DHS and MDH maltreatments are when the DHS or MDH looks into allegations of maltreatment occurring in the programs that it licenses. And then the counties would look into allegations of maltreatment in the private home. And the determination of maltreatment and the appeal rights of maltreatment are separate from the disqualification and the appeal process there, but there can be some overlap. When substantiated maltreatment is disqualifying is when it is determined to be serious and or recurring. I gave you a couple sites there, but 245C.02 is the definitions section, and that defines both serious and recurring. So serious is sexual abuse, and then certain levels of physical abuse or neglect, and then recurring, of course, is more than one incident. So maltreatment could be found to be serious only or recurring only, or it could be found to be both serious and recurring. And let's see. Sorry, was there a question?
Yeah, may I ask a clarifying question? So,
yeah.
Am I understanding right that before it even gets to you guys, the counties make a determination of whether the maltreatment happened, and then once it gets to you guys, the sort of the exercise of discretion is determining whether it's serious and or recurring?
Correct. So the county does its investigation, and it issues a notice when it finds that maltreatment is substantiated. It will give a notice to the person, the subject, if you will. I don't want to confuse terminology too much, but it'll give a notice to the person who's been investigated, saying, "Dear Katie Ryan, you have been found to be responsible for maltreatment of your child or maltreatment of a vulnerable adult. And here is what you can do to challenge that finding. That may or may not ever have to do with a background study, because a person could be found responsible for substantiated maltreatment and never have any reason to be affiliated with a program that would require a background study. So the determination of maltreatment is its own thing. And then DHS looks at the maltreatment substantiations and reviews the investigation records and determines whether the information in those records would support a finding that the maltreatment was serious and or recurring. If it's neither serious nor recurring, then that's not disqualifying maltreatment. If it is serious and or recurring, then it would be disqualifying, and there's an evidentiary hearing. Of course, the first step is the written reconsideration process, but the next step would be an evidentiary hearing, which would be like a fair hearing with a human services judge, and that is for the first time that someone's disqualified for that maltreatment. It's the same hearing right as the first time preponderance of evidence determination. Here's where they might intersect again. If the timing of the disqualification and the timing of the maltreatment notice are close enough in time that maybe those two hearings could be consolidated, then ideally those would be consolidated so that it's one process that would be separated, but it would all go in one process.
Okay, can I ask another follow-up, please?
Yeah.
So assuming that we are beyond the point of challenging the county's determination that the maltreatment happened, then any challenge would just be about essentially whether DHS correctly determined that it was serious or recurring. Is that right? Not
That's
whether
right.
it happened.
Correct.
Okay. And then could you elaborate a little bit more about sort of what types of things you grapple with in making that determination? And because it seems to me that whether something is recurring or not is just a question of whether there's more than one incident. That seems like more often than not to be pretty bright line rule or distinction. And then to some extent, I would think if it's sexual abuse or not might also be, whether it's sexual in nature anyway, might also be a pretty bright line. Maybe categorizing what types of physical abuse or neglect might be more difficult, but I'm just wondering, like, where, what are like the marginal cases here that you struggle with? So
for the serious maltreatment, actually the physical abuse and neglect have to meet certain thresholds for injuries, and so you might want to take a look at that. It's more than I could put in just one slide here. It's actually the more I can't remember how you phrased it. The more challenging reviews would be on the recurring determinations, because I could be, let's say I have 2 kids in the home and I'm high. I'm two kids in the home and I'm high for 3 days and I'm unable to, care for the children, and then something happens or doesn't happen. And if that has been found to be maltreatment, DHS would have to consider what was the conduct, what was the act itself, right? Was there a break in the act where it started up again, or was it one continuous act? Does the fact that there were more than one people affected rise to the level of recurring, or do separate things have to happen in order to make that recurring?
Interesting. Thank you. Okay.
Does that help?
Yeah.
Okay. Good. We can go to the next slide then. So now we'll take a deeper dive into POEs. So when we say preponderance of evidence, we shorten it to just say POE. So please work with me there on using the POE phrase. POE means more likely than not. It's a lower standard, of course, than the beyond a reasonable doubt, and it's a lower standard than clear and convincing. It is the same standard as maltreatment reviews and other determinations that are made by DHS. DHS is required by statute to prioritize the safety and well-being of people served by its programs and also the integrity of its programs. And so the preponderance of evidence review, or the POE, allows DHS to identify conduct itself, the underlying conduct that, if proven to be more likely than not have occurred, would pose a risk to the people and or the programs. Next. Which cases are reviewed? So Chapter 245C requires that when a preponderance is found, the disqualification must be based on that preponderance. But it does not identify which cases need to be reviewed for a potential POE. So DHS uses a set of guidelines for consistency to determine which cases are actually reviewed, which cases are sought out for additional records and sent for a review of the potential POE. We do have a guidelines document that we are happy to provide if that would be something the group would be interested in. So the guidelines focus mainly on the permanent disqualifications, violent crimes, and what I'll say there is we know that there are different parts of Minnesota statutes that list out violent crimes, so we use the 609.1095 list of violent crimes. And then the guidelines also focus on domestic assault and then conduct occurring against vulnerable adults or government funds. In 2017, there was a change to the guidelines that kind of bumped up the requirements to require a criminal charge in order for a case to be sent for a POE review. So there are cases where a POE was found before then and has not been overturned. But for cases that are reviewed from 2017 onward, the guidelines would require that to be the first cut in determining whether to even get records and review for a POE would require a criminal charge.
Can I dig into that a little bit more? Sorry.
Sure. No, that's okay.
So can you, I guess the first question is, does it start with getting court records then? Is that how you determine whether there's a criminal charge? Like you go to MNCIS first and then the BCA if you see a charge?
Yeah, so it could happen a couple different ways. So all studies require a BCA check. So there could be evidence of a criminal charge there on the BCA record. Studies require some studies require an automatic FBI check and some studies require a conditional FBI check. So if certain information is present, then an FBI check would be done. And so there could be evidence of a charge there. But if there's not information about a charge and it's a case or it's information that would be potentially related to the guidelines, then MNCIS would be checked.
So, okay, so you're going to know if there is arrest information that hasn't led to a charge. You're just not going to follow up and do a POE investigation if it hasn't been charged. Am I understanding it? Okay.
Correct. I just want to, so yes, you're right. It could be though that we receive information about it, what appears to be an open arrest on the BCA record, and then we look into it and we actually see that there is a charge in MNCIS. And so then we would potentially look at a POE if it would meet the guidelines.
All right, and it sounded like maybe there were some categories of, criminal statutes, I guess, for which even if there's no charge, you still would investigate. Is that right?
So I would have to look at the guidelines again, and again, we're happy to provide those if you're interested. I think the categories that are not necessarily related to criminal charges are potentially more related to internal investigations of maltreatment or misuse of public funds off the top of my head. So in other words, if we see a record where there's an arrest for murder and there's no charge, that would not be sent for a POE typically.
Oh, okay.
Yeah. But again, I would just think, if you're interested to see the guidelines, that's where you'd find the information.
Yeah,
And
I would
I
very
think
much
I
like
could-
to see them if we could, but if I could ask just one more question before we move on. So the timing of this update 2017, that's, am I right that that sort of coincides with a new commissioner?
No, I'm digging
No?
deep here. I don't think that coincides with a new commissioner. DHS is just, we review our policies and look at what we're doing and consider whether that needs to change. I don't recall that being tied to a commissioner change.
Okay. I thought that maybe like 2016-ish there was another commissioner, but I could be wrong on that. But the reason I ask is because honestly, I'm really happy with that update from my perspective. I think that makes for a more fair system than it was before that update in 2017. But could it there's nothing stopping it from changing back to the way that it was working if there was, a change in priorities within the agency. Am I right on that?
That's right.
Okay.
And Ms. Ryan, I think I'll just jump in here really quick. I think it would be very helpful if you did provide that guidelines. If you could provide it to Mr. Vogel, that would be great. And then Mr. Tatum, I noticed that you've had your hand raised as well as you, Ms. Evans, but I think Mr. Tatum was first.
Thank you. Yeah, I just wanted to make sure I'm understanding this correctly. The update, like where it says, right, reviews required, the criminal charges update. What is the update? Was it laws change, or is it update systems? Could you explain that a little bit more for me?
Yes, of course. The update was changing the internal guidelines that didn't previously require a criminal charge to now requiring a criminal charge. So that it was unrelated to any law changes. The 245C doesn't actually provide any requirements for when a specific case should be reviewed for a potential POE. So it's just internal guidelines that are used. And so the change was requiring a criminal charge starting in 2017.
Okay, yeah. The reason why I asked that, because I had a problem with this. I was wondering, like, when did the change go in effect? Because I took a background study and before I started my classes, and before I started the semester. But at the beginning, I started the semester in the beginning of the semester, and then later I got in 2013 I got a set aside work under supervision. Then I left school, come back 3 years later to finish up to get my degree, and now I don't qualify. I'm disqualified permanently now. And that's what I was trying to wonder, like, where did that come in? Where did they update? Where did the changes come from? I haven't got a lot of information for that because I was getting back and forth with like a lot of writing and not really getting no really full answers from anyone.
Did that answer your question, Mr. Tatum? I think you're on mute, I believe.
I understand what you said about it just was an update of the system with the charge, but I'm trying to figure out myself, like when, like you said, these going to affect the actual charge and the preponderance of evidence separately. I'm just truly trying to understand that correctly and figure out like what changed for me and like what these changes are and how they are affecting it, is making it easier or better for individuals.
Okay, yeah, I think it sounds to me like I've answered the question then, that the change in 2017 was an internal policy change because the statute doesn't have any specific requirements around that. Was there another question, or did you have another question, Mr. Tatum?
Nope, I think that was me.
One second, Gina. Yeah, yeah, she said the policy change. Okay, so it was changed in like what we're doing now, somebody was doing this before. And the policy change you're saying, could you explain that? That's what I'm trying to get that in full detail so I can really understand that correctly. Like you're saying with the Did they go in front of the Senate and do changes actually as far as what criminal crimes background? Or are these are just updates? I'm just trying to really like understand that correctly.
So the statute itself requires that if information is found at a POE level to be disqualifying, that the disqualification must be issued. But the statute does not require, so the legislature has not told DHS, here's the scope of study of cases that you need to look into for a potential POE. These are the types of cases or potential conducts that you have to review and determine whether there's a preponderance. And so in the absence of a formal mandate or a statutory requirement, then DHS has to determine on its own which cases to look into for a potential POE. If a POE is not found, then that conduct would not be disqualifying. But if a POE is found, then the conduct is disqualifying. But so the policy is, because there's not a mandate or a statutory requirement, DHS has to determine on its own then which cases to look into. And so that was an internal decision to change which cases, how to look at cases for a potential POE. Does that make it a little bit clearer?
Yeah, I get it now. I get what you're saying. Yeah. What cases to look into and all. I'm just I've just really been confused about a lot of it, not just what you Ms. Reiner, what you displayed here, but it was just like I'm still trying to figure out like why did the changes happen? Like far as with my situation, like being like you said, work under supervision I was granted that, and then the changes happened. Nothing as serious as happened since it was a attempted ag robbery in '97 and a DUI later on when I came back, DUI. And so I'm just like, so I was just really confused about it and having my degree now, and that's where I'm just trying to put some pieces together because I wasn't getting a lot of information when I was writing back and forth with my lawyer. So I was, and it was kind of, it was kind of scary, lost a lot of motivation behind it, but kept going though, and I can imagine how it is for others though, with a lot of people just quitting right away. I'm done. Oh, yep.
Yeah, Ms. Evans?
So first of all, just to help Duan, because I know that it's really niggling at him. Can we find out when attempted aggravated robbery got added to that permanent disqualification list? Can you do the little 1s and 2s on the statute and figure out when that got done? I'm guessing it was right around that time that they either added the attempted or moved some stuff around in the statute. That would just help him like to figure out what exactly happened to him.
You know what,
I'll look into
Gina,
that. Oh.
can I, why don't I'll volunteer Cassie and I, we'll connect with Dewan and see if we can do that. I think maybe, we could do that more efficiently than,
Okay.
than Miss Ryan, who cause we know DHS is already, bending over backwards to try to get us as much information as they can. Is that okay, Dewan? Would you want to connect with myself and we'll dig into it?
Yeah, we can look it over. It's not no rush. I'm patient about it. Just was hearing a little information and knowing a little bit more. That's all, like because of like the process, like I said, it could be scary for other individuals. And like I've been working with you guys for a few different meetings, and I'm still just now learning a little bit more. And I've been in this process for a while and been paying attention. I thought I was, but it's just been, it's just been a hassle, but I've been being patient. It's been working itself out slowly but surely. But yeah, I really appreciate that, Josh, if you could, and whatever, in a big rush or anything.
Yeah, because I'm really curious about what happened with you too. So I'll send you an email later on today, and we'll set up a time maybe to meet with myself and Cassie. Okay.
Okay.
I'm guessing that was a legislative change that happened, not a rule thing that happened at DHS, Duan. So. And then the other question that I had for you, Katie, is about, so I was just looking through the 245C16 risk of harm recency stuff. And do your guidelines talk about those recency things, because one of the things that I've seen come up lately a lot for people that are getting disqualified is that recency. And so I just am curious about do the guidelines have some real definitive rules for your what do you call them, case managers, or what do you call the folks that are running applications?
We call the team that does the actual
Reviews.
the bulk of the determinations, we call them researchers.
Okay.
And it's attorneys who do the POE reviews.
Okay. And is this presentation that you're doing right now just around POEs?
I'm trying to cover a variety of areas where DHS exercises discretion. So yeah, this portion of the presentation is just on the POEs.
Okay.
So I'm trying to cover a few other topics we've heard asked about.
Okay. So,
Yeah.
okay, perfect. I'll wait then for my questions to get further along.
And Ms. Ryan, just really quickly, because there was a question I had. So, because one of my questions was who is actually doing the review. So I think you just said it's attorneys. Can you just tell me a little bit more, just so I understand who the people are? Is it a team? How do they have like consult with each other? Is it just one person who does it? Just really briefly. I know we have a lot of questions, so just briefly.
Ms. Dawson, you're actually a couple slides ahead of me, although I didn't have a whole lot of detail about it. No, this is fine. This is fine.
I can wait. If you have a slide, I will wait.
No, let's talk, because then I can just touch on it when we get to the slide and we'll keep going. So the group of professional employees who are not attorneys are the ones who review records, determine which cases to actually send to legal for review, and gather those records and then send them to legal for review. We have a team of attorneys. Currently, we have 6 attorneys who actually review these files for a potential POE. And they work together very well. They communicate on a case-by-case basis, but they also have formal, like, recurring meetings where they discuss whatever they need to discuss in terms of cases that attorney to attorney you'd want to talk out. So where reasonable minds can differ, yes, it's always possible that there could be differences of opinion or differences of conclusion, but they do strive for a great deal of consistency in their decisions. Does that answer your question, Ms. Dawson?
It does. Thank you.
Could I ask a follow-up on that though, please? So is there like a process where like one of the 6 gets assigned a case and ultimately it's their decision? Or is there does the process require some kind of unanimity? It doesn't sound like it requires unanimity, but some group decision.
It's not like an appellate court panel or something like that. It's each attorney has their own cases, so they make their own decisions, but they consult as they feel is appropriate.
Okay.
Each other.
I think we should move on, but something that I'm curious about, just to sort of think about as we move through the slides, is like what guidance or feedback, or I guess training, sort of guides those 6 in their decision making. But that's kind of a broad question that I'm kind of hoping we'll be able to glean more from as we move through the other decisions.
Okay, so let's keep going and see what other questions pop up. Well, could you go to the next slide, please? So in terms of which records are actually reviewed for a POE, we've got 245C08, which lists the types of records that DHS is required and authorized to review. So there's, of course, the BCI, FBI, law enforcement records, which would include, the police reports, which could be the narrative and supplementals, and written, interview transcripts if they're available, audio, video, photos if available, court records, which would include the MNCIS or the MGA record, like the Register of Actions, and other related documents. So, if there's a sentencing order or a dispositive or even non-dispositive motions and orders, where we could get more information about the merits of the case. We'll look into those. And then in the maltreatment investigation records as well, because sometimes maltreatment is related to a criminal case. One thing I wanted to point out though is that DHS does not conduct interviews in the process of reviewing a record for a potential POE. Two main reasons: interviews are not authorized in 245C, and also data privacy for study subjects is required by both 245C and the Government Data Practices Act. Next. So again, here we are. The POE reviews are done by attorneys. They're licensed to practice in Minnesota. And just a kind of a quick overview of some of the factors that they use to analyze. Detail, is there a lot of detail in the statements? Is there a lot of detail in the investigation itself? Is there information that seems like the most relevant people or all the relevant people have been interviewed? What's the timeline? When was the allegation made? When was the investigation made? Is that significant? It may or may not be for certain types of cases. Credibility, we look at, is there consistency among statements of people who would have had a similar opportunity to observe? Also, is a statement consistent with a photo or a video or audio? Is there any potential bias? So would somebody who gave a certain statement have had motivation to be untruthful or to cover for something? Or would they have, was it, if it's a child, was the statement given in childlike language, in kind of age appropriate language, things like that. A note about hearsay, because there's a lot of, obviously, because these aren't direct interviews, hearsay is admissible in these evidentiary hearings because these fair hearings are not conducted in the district court, and so they're not subject to a strict application of the rules of evidence. But the judges do have the authority to determine what weight to give hearsay statements. And so that's something that we also consider, is this hearsay likely to be given great weight? And then we look at dismissals, whether it's the court or the prosecutor dismissing a case, to see if we can get information about whether the dismissal is related to the merits of the case. So a lot of dismissals are, they just say, in the interest of justice. That doesn't give us much information. But sometimes it'll say that, the alleged victim or a key witness is unavailable, or that somebody who gave a statement that would be a major impact has recanted. Look into, which statement to believe and why. Sometimes the dismissal is related to a procedural issue, a constitutional issue that's not necessarily tied to the question of whether the conduct itself occurred. And sometimes there are plea deals where, plead to this other case and we'll dismiss the first case, or plead it down and we'll make sure that, the conditions of probation include the appropriate programming that will help the person. But again, that's not necessarily related to the merits of the allegation. And just for perspective, of the files that are sent to legal for a POE review, a POE is found on about 40% of those files. Mr. Esme?
Yeah, you knew I was going to have questions of you. I'm sorry. This is so helpful, though. I just want to say I really, really appreciate this. So I guess the first question I have is, do you know if that 40%, how stable that number has been sort of year over year going back? Is it less now than it was 5, 6, 10 years ago, or does it vary a lot?
Short answer is I don't know. I mean, it hovers around 40, I'll say, in the last few years, but I couldn't tell you 10 years ago compared to now off the top of my head. Yeah.
And I also wanted to ask, could you dig a little bit more into sort of what happens when, you've got a higher level charge, maybe that, would be maybe a felony charge, right? That gets pled down, in terms, so maybe you've got, like a felony assault where it's there's a serious bodily harm, but that it gets pled down to like a 5th degree assault and there's no finding of serious bodily harm.
Yeah.
Like what's sort of the standard procedure in dealing with that and determining whether or not there should be a POE on the higher charge?
You're about a half a slide ahead of me there.
Okay, I can wait
I'm
then.
happy to take it. If you don't mind, there's one other thing that I wanted to capture here that I forgot to put in this current slide. And I know that I was getting concerned because the letters were getting pretty small. But another factor that the attorneys look into is, looking at in the MNCIS records, looking at the conditions of probation to see if there's anything that is informative there in the conditions of probation. Okay, so in terms of, let's see, determining the offense and the level. So, Will, could we go to the next slide, please? So, I think part of your question is here and part of your question is not here. So, when a POE is found, the DHS attorney writes a memo explaining why the POE was found, how it was determined, what was the analysis behind that finding, and then how they determine the level of disqualification. So, when there's a sentence from the criminal case that's related to the POE conduct, then DHS honors the level of sentence that we can read in that criminal record. So an example here, and I've got an example here of a gross misdemeanor assault 5, but I can give you a different example too of like an assault 2, because it would be a little bit different. But in the case of a like if we've got a charge for a gross misdemeanor assault 5, and it's found that yes, there is a preponderance that the assault, was committed. But then maybe they pled to disorderly conduct, received a misdemeanor level sentence. The disqualification would be for a misdemeanor level assault 5. So it wouldn't be a 10-year disqualification, even though gross misdemeanor would be a 10-year. The disqualification would be for the misdemeanor level assault 5. Another example, which Mr. Esme, I can do a couple variations on this, on another example, which may be more closely tied to the question you asked. Let's say someone's charged with assault 2, which at the felony level is a permanent disqualification, but at a misdemeanor level is a 7-year disqualification. Big difference, right? Because the one is a permanent bar and the other is a time-limited disqualification with a set-aside rate. So if there's a charge for assault 2, and that's sent for a POE review, but let's say there's enough evidence in the file to find that the assault occurred, but there's not enough evidence to find that a deadly weapon was used. In that case, the POE would be found for assault 5, even though it was sent for a review of potential assault 2. We would find a POE of assault 5 and give them a misdemeanor level sentence there. Another example, another variation on that assault 2 example would be if a POE is found, assault of conduct is there, plus the dangerous weapon is there. So there is a POE of assault 2, but let's say they pled it down to disorderly conduct, received a misdemeanor level sentence. The disqualification would be for assault 2, but it would be at the misdemeanor level, not at the permanent level. So in that case, the POE, they were charged with assault 2, received a misdemeanor level sentence in district court. The POE, if found for assault 2, would be a misdemeanor assault 2. That would be a 7-year disqualification with the right to a set-aside. Did that answer your question, Mr. Esme?
Yes, it did. I didn't know that, and that is awesome. What if same assault 2 though, but an acquittal after a jury trial? What do you do then?
So that could be reviewed for a potential POE. If it's found, I think that gets us to the bottom bullet point here. When there's no criminal sentence, then there's not an official benchmark to compare that level to. So then the statutory level of the offense would be used.
Does the jury finding factor in at all?
That could factor into whether a POE was found.
Okay.
There's
I-
not, yeah.
I mean, I assume it would weigh against the POE, not necessarily determinative, but
I'd say it's pretty rare that POEs are found when there's an acquittal by a jury.
yeah.
But I wouldn't speak, I can't speak in an absolute, but in that scenario, if a POE were found for a case that resulted in acquittal, then the statutory level would be used for the disqualification.
Yeah.
And another note here, just that again, for most disqualifications, the level does impact the length of disqualification, but for most of the permanent disqualifications, the level of offense is not relevant because most of the permanent disqualifications are permanently disqualifying at any level of offense. There's only a handful, like assault 2, for example, that are only disqualifying at the felony level. So that's another cut that's made in that conclusion.
And this isn't really just a question, but something that I've observed that I think we should be thinking about is that the statutory scheme creates a little bit of a weird result in that situation where, you know, plea bargaining to something else can lead to, at least potentially, a better outcome vis-a-vis the DHS background study than having the charges dismissed or an acquittal. Where in cases where you could still be at risk of being found to have committed the act by the performance of the evidence. But yeah, not a question. So
no, I understand what you're saying. This I think is the end of the POE. So were there any other questions about POEs? Any questions that I hadn't yet answered about that process? We're going to talk reconsiderations next, so that will wrap up some POE information as well. So reconsiderations, just a note about who actually does reconsiderations. So DHS does reconsiderations for all programs that it licenses or regulates or certifies. And we also do reconsiderations for programs that are certified by MNDOT. But MDH does its own reconsiderations, and the Department of Corrections also does its own recons. And so just want for perspective here, when I'm talking about the process and how things are analyzed, when I'm talking about anything other than what the statute requires, I'm really only speaking for DHS. And I want to just put that out there because MDH does a substantial portion of reconsiderations. Next. So the first thing in the reconsideration analysis is, whether there's a bar. Most the disqualifications that are required by state law and the bars that are required by state law, most of the permanent bars are required only by state law. But some are required by federal laws. And I know I've spoken at a high level about this in previous presentations. So I just wanted to give some citations, if that's a helpful starting point for the most common program types that are subject to federal requirements. So for childcare programs, that would be licensed or certified programs, and some small group of non-licensed programs that are still subject to regulation. Disqualifications are actually enhanced in some ways. So all the disqualifications from 245C would apply to childcare programs, but also some disqualifications that are time limited under 245C bump up to permanent. The example I can give you is like a misdemeanor malicious punishment of a child. For a nursing home study, that would be a 7-year disqualification. May or may not be timed out at this, on this date. But let's say it's timed out. And for a childcare study, that would be a permanent disqualification. That's from that federal childcare law. There's also child foster care and adoption studies are regulated by federal law. There's again, there's a lot of overlap between 245C and the federal law, but just wanted to point out that our state statute doesn't have all the discretion to make changes. And just to note also that there's a slight difference between foster care studies and adoption studies. So foster care studies apply to the actual contact or access for the child. So it actually, they determine whether or not the child can actually be in the home in a situation where it's funded through the foster care system. Adoption studies, on the other hand, are only focusing on whether that prospective adoptive family is eligible for federal funding. So DHS doesn't actually determine whether the adoption should be approved. The district court makes that decision. So you could have a situation where the district court approves the adoption, but there's a barrier to adoption assistance funding, so there's no funding for that family, even though they can legally adopt the child. So anyway, the federal law does have some requirements in there about what the standards are and where the disqualifications or barriers are. There are a couple others, but these are the main federal laws that affect our programs.
Ms. Ryan, if I may,
Mm-hmm.
do these federal statutes, and I'm just not very familiar with them, so I see that they sort of impact the length of the disqualification. Do they themselves also impact which offenses trigger the disqualification?
Yes.
Yeah, they do. Okay.
They list specific types of offenses in the statutes, and then they, with a very rare exception, they don't have time limits on those ineligibilities, or however they're phrased. They're phrased a little bit differently in federal law, and so that would be for us that would be a permanent disqualification and a permanent bar, because the federal law doesn't allow for allowing them to have the access or to have the funding, notwithstanding the disqualification.
And the federal statutes also don't have a remedy mechanism, finding rehabilitation.
There are, I'd encourage you to take a look because it's a little bit nuanced. There's a little bit of remedy, but by and large, it's permanent DQ,
Yeah.
permanent bar. There's a little bit of trust but verify what I'm about to say. I think in the child care federal law, there's the ability to get a set aside for certain types of alcohol related offenses or drug related offenses that were committed in the last 5 years. But there's a little bit of nuance there, but by and large, it's permanent.
Okay, thank you.
In the federal laws, yeah. And then there's a Head Start statute that's very similar. It's not totally identical, but it's very similar to child care, because I know a lot of programs for Head Start there's a lot of overlap with child care.
Are these the Adam Walsh Act?
That would be the foster care and adoption.
Yeah. Okay.
Child care is separate. Yeah. Okay, so let's go to the next slide. So jumping back into just the requirements in general for studies for reconsideration, all types of disqualification are eligible for a correctness review every time, regardless of whether or not there's a bar to set aside. So the standard of the request must be in writing, it must be timely made, applies to correctness reviews. There's a conclusiveness provision in 245C.29, but that applies to hearing rights. That applies to whether or not they are eligible for that fair hearing, that evidentiary hearing. It doesn't mean that they're not eligible to challenge the disqualification. So just want to be clear that everybody who receives a disqualification, is allowed to challenge that disqualification every time, regardless of what their appeal rights might be after that first level. So then in terms of risk of harm reviews, all disqualifications except bars are eligible for the risk of harm reviews. And of course, the risk of harm review is for a potential set aside. Again, it has to be requested in writing and timely. Just, I threw this in here just so that you have another place of reference, the difference between the disqualification and the bar. Disqualification is the result of the background study. Bar is the prohibition of set aside of that disqualification. And then all permanent disqualifications are also permanent bars, but they are still separate. So to just give a quick illustration in case there's any, in case that might still be a little bit confusing for people, especially with the permanent disqualifications and the permanent bars. Hypothetically, if we just pretend for a moment that the bars did not exist, then a permanent disqualification would still be permanently disqualifying. So a conviction for murder would always be disqualifying, but it would immediately be eligible for a set aside. So the study subject with a conviction for murder would continue to be disqualified, but they would be allowed to request a risk of harm review and a potential set aside each time. That's what it would look like if the bars didn't exist. Hopefully that distinguishes the DQs from the bars. Next. Risk of harm analysis. This is for potential set asides. Of course, there are factors that are laid out by the legislature. The factors focus really on the conduct of the study subject, the disqualifying conduct and the vulnerabilities that are associated with the people and affiliated with the programs and the programs themselves. So because the needs and the priorities of programs differ from program type to program type, some information might be more significant for one program and less significant for another program. And again, we're required to prioritize safety and well-being and also program integrity. Because the programs have different needs, a study subject could receive a set aside for one program and not set aside for another program. So for example, somebody could be set aside to provide PCA services for their parent, but not be set aside to work in a child care center. Disqualification letters, we're in the process of continuing to update, but a while ago we started updating disqualification letters to include information that a person's not required to hire an attorney for their reconsideration, but they do have the right to hire an attorney for the reconsideration, and there's information about where they might find low cost or no cost legal services. And the disqualification letters also have long ago included a suggested form for requesting reconsideration. As part of the updates that started a few years ago for these letters, though, the suggested form is actually far more personalized now. And so it's a good starting place because it covers all of the factors that DHS would consider in evaluating reconsideration request.
Has that been helpful, do you think? Are you getting better responses with the new form?
Yeah, I think, the old form basically just said, for the correctness review, it's it is what it is. Do you think your disqualification is incorrect? And if not, tell us what is correct. And if not, tell us why. But for the risk of harm factors, it's been very helpful because people have different abilities to advocate for themselves. Especially in writing, different people's strengths are in different areas of communication, and so the new form actually lays out all of the factors and says, tell us about the people served by this program. What are the types of people served by this program? What was your conduct related to this disqualifying characteristic? So it goes through all of the specific factors and really leads them through that analysis that we're doing anyway. So it has been helpful. And those of you who are representing people who have been disqualified have probably seen those in the files. You've probably seen the new forms.
Yeah, they're good, I think.
Mm-hmm.
Um,
Next. Oh, Go ahead.
Could I just ask, is there, it doesn't look like there is, but I just want to clarify, is, there's lots of news stories, especially in healthcare, about, need to find staff and staffing shortages. Is that something that comes into play at all in deciding whether someone is, could be reconsidered?
By could be reconsidered, you mean?
Yes,
the
could be
set-aside
granted set
analysis?
aside.
So we are always evaluating our analysis. We're always, striving to make sure that we're assessing risk appropriately. But risk of harm is risk of harm. So it's not something that's necessarily been relaxed or changed in the environment that we're in now. It's not something that was, part of any legislative waivers. So risk of harm is continued to be reviewed with the understanding that we're constantly reviewing ourselves, our own approach.
Ms. Evans, I see you have your hand raised.
Thanks, Ms. Dawson. Katie, I just wondered, so a couple of years ago as an industry, we put some legislation in place to get what we've been calling a traveling set aside. That says that if somebody's been granted a set aside in a treatment program, what it would look like is then if they move to another treatment program, that set aside would travel with them. And on the new forms, I actually have seen a little box that says forgive me, I'm not going to get this right, but something along the lines that, I've had a set aside before and I'd like you to use this information or whatever. It basically looks to me like a release of information to use the other information. But we're not seeing that is in practice working like we intended for it to, because when people move even to another building within our own organization, they're still having to go through the whole set aside process over again to another address of ours, let alone to another similar program. And so tell me, if you can, what happened that's not working how we intended? Is there language legislatively that we could make that work how we intended? Is there a question I'm asking that I should be, that I'm not?
Let me just, first question to clarify, you're talking about substance use treatment? Okay. So the legislative change that came up a few years ago basically created a scope of mandatory set-asides that would be for people who associated with substance use disorder treatment programs. And the definition of substance use disorder treatment programs is in 245 CO2 specifies that those programs are serving adults. And so I don't know exactly, without looking at each specific scenario that you have, Ms. Evans, I don't know. I'll try to answer a variety of scenarios that might be addressing what you're raising. So it could be that, maybe one of your programs serves all ages and another one serves only adults. And so that could be where those set-asides are not able to travel, because if somebody received that mandatory set-aside, that can only travel to another program that's only serving adults because of the definition, the way it's written in the set-aside provision and then in the definition. So that could be part of it. But DHS does, this is where I also have to say, I believe MDH does some of these recons. So I'm, again, only speaking for DHS. DHS, because of that limitation on how those set-asides could travel, DHS first looks at whether a permissive set-aside should be granted. And when I say permissive set-aside, what I'm talking about is the standard set-aside that would apply to any type of program. And because the thought process is, if we could grant them a permissive set-aside, then that would travel more easily than the mandatory set-aside due to the age restrictions in the way that substance use disorder is defined in 245C. So there's a little bit of a catch there because I think I may have to check myself here, and Ms. Evans, please check me too. But I think that felonies can travel under the SUDT mandatory set aside provision, and they're not allowed to travel in the permissive set aside provision. So it's, you know, it's kind of a catch, because if it could travel across more programs as a non-felony, I mean, it's tough, right? Because is it going to stop because it's a felony, or is it going to stop because of the age limit for that program type? Another thing is that obviously we safeguard data privacy of study subjects. And so it could be that a set aside is not granted, potentially based on a risk of harm analysis, or potentially because it's a permanent disqualification. And the program isn't notified that they're not set aside because it's a permanent disqualification. The program would just be notified that they have not been set aside. So I don't know if that's playing into your situation either, but does that answer any part of your questions? I think you're on mute.
Yep. So none of them would have been permanent. They're people who have already been working, moved into another program or another part of our program. And so that first stuff that you talked about, though, could very well be accurate with because we have some programs that have juveniles, other programs that don't. And so I think that you're probably onto something there in answering our question. And I think any remedies that we come up with, I think that's going to be key for us to understand that risk of harm when there's juveniles involved is going to be a little different than when there isn't, and probably part of some sort of negotiation that we made with the legislature was that it was going to be adults only. So that, I mean, I'm reading into that, of course, but that makes sense. So thank you.
Okay. You're welcome. Any other questions about risk of harm before we go on? Okay, let's go on to the next slide. So appeals, I know we've talked about these before. I'll just touch briefly here. First time disqualification for maltreatment or first time disqualification for a POE would be eligible for a fair hearing, an evidentiary hearing that would include testimony and exhibits. That happens after the reconsideration stage. And one thing to note is that even if a study subject is no longer trying to work for a certain provider, or maybe the provider has already said, I'm not going to hire you because I received the notice that you're disqualified. The study subject's right to have that fair hearing is right now. And so they, if they don't exercise that right at this time, at the time that they're, within the window of appeal for that first time disqualification, they would lose the right to have that hearing. They could still request reconsideration. They could still challenge correctness and risk of harm if it would be applicable, but they would go to the Court of Appeals if they don't have that hearing right anymore. And hearing rights for the POE and maltreatment DQs are given opportunity for the study subject to have testimony and evidence in a hearing in a similar way that convictions and admissions go through the district court process on the merits of the underlying allegations. And then, of course, convictions, admissions, conclusive POEs, maltreatments, the termination of parental rights would go to the Court of Appeals after reconsideration. That's all I have on reconsiderations. Next is expungements. Next, Will, thank you. There are different statutes that govern adult and juvenile expungements. Of course, 609A governs the adult expungements, and it provides specific criteria for what types of offenses and what types of dispositions are eligible at what time for expungement in adult court. So I'll just note here that the 12-factor analysis for expungements in adult court is very similar to the 9-factor risk of harm analysis for set-aside determinations in the Background Studies Act. Juvenile expungements are more broadly allowed to be granted in the statute, but there are still 8 factors that the courts consider. So there's giving you the statutory citations there. And just to note that DHS receives a lot of petitions every year, and we object to about 2% of the petitions that we receive.
Could I ask a couple? Go ahead.
Well, we might be going in the same direction. My next slide is a little bit of a deeper dive in DHS objections. Is that where you were going? Okay. So let me know if you have any other questions when we discuss this. So DHS reviews expungements and handles the expungement work on behalf of both DHS and MDH. We handle MDH through an interagency agreement. And the factors that we, and again, these are, let's see, the factors in determining whether to object. One cut is whether the petitioner has had a background study or any other significant involvement with our programs. If there's no background study, we would be less likely to object. Or sorry, if there's no background study or other involvement with our programs, we would be less likely to object. But there are situations where there's information in the petition saying, I want to go to medical school, or I want to open my own daycare, that gives us a good reason to believe that they will be through our system and that their record is relevant to us. Another consideration is occasionally we have, upper teens or young adults who are petitioning for expungement, and they're maybe not sure how they would articulate their career goals. And so given the broad scope of studies that DHS does, that may or may not be a deciding factor for whether to object. We also consider whether the subject would be eligible for a statutory expungement. If they're not eligible for a statutory expungement, there are times when DHS would file an inherent objection, which would just clarify to the court that although it has inherent authority to seal its own records, it doesn't have statutory authority to order DHS to seal. And we would file those objections in cases where we would have objected if that petition had been eligible for a statutory expungement. Courts don't always follow the exact statute. So there are times when we've been ordered to seal when it didn't align with the statute. So that's why we sometimes file those inherent objections. And the 12 factors for adults or the 8 factors for juveniles, again, are very similar to the risk of harm factors in 245C for the set-aside analysis. And so we look at whether the petitioner would be likely to get a set-aside for a variety of program types. If they would be likely to maybe only get a limited set-aside for a PCPO, that might tell us something, or if they'd be likely to get a set-aside for a variety of programs, then we'd be much less likely to object. That's all I have on expungements. Were there questions about expungements?
Yeah, I have a couple. Does the nature of the offense that the petitioner is seeking to expunge factor into whether you would object? I mean, are you more likely to object to something that's a permanent disqualification, or is that not really part of it?
The nature of the offense, yeah, it's one of those factors that overlaps the expungement factors and the risk of harm factors. So, the nature, the recency, or nature, severity, the recency, proof of rehabilitation, all those types of things would be considered factors. There's not a bright line like we would always object to a permanent bar. I mean, we need to look at the factors and determine whether there's an actual risk related to the conduct for programs that are served by DHS. Background studies.
Gotcha. So that's subsumed in the bottom bullet point. I gotcha.
That's right. Yeah. Yeah. And so to clarify to clarify the confusion there, let's pretend for a moment that there were no bars, right? So that when we talk about a set aside, if they'd be likely to get a set aside. I'm talking about hypothetically if the bars didn't exist. You know, do we see a risk of harm for programs that we study?
So similarly, like, you know, someone with a misdemeanor that's already 6 years into their disqualification period might be an easier one for you to not object on than
Yes.
something that's more recent where you might look at it and say there's a higher risk of harm. Here.
Right. If it's pretty recent, if there's a pattern of conduct, or the nature of the conduct alone could be enough. It just totally depends on, you know, each case specific analysis.
I know this is something that's come up a little bit, and Ms. Ryan, I think maybe you and I have even corresponded about this, but there's the issue with expungements being able to be granted either under 609A025 without a petition, or I think even the juvenile statute theoretically allows a judge to grant an expungement without a formal petition. How does that factor in with the statutory language that you guys have that requires you to look at records notwithstanding an expungement unless there's a petition served on you?
Yeah, I mean, there's a little gap there. And so what I can say is DHS has not appealed any of those orders that are coming out of those stipulated expungements. There is a disconnect there because DHS is required to be served with a petition in order for an order to be validly issued against DHS. So there's a gap there, but we're applying the same analysis, right? And would we object? And to this date, we haven't. If we are ordered to seal, we're either going to appeal it or we're going to seal it.
Okay, so there's no circumstances under which you just ignore it without a formal appeal.
Ignore a court order? Oh no.
Yeah.
We would not ignore a court order.
Yeah, I figured.
There are times when we don't get served with court orders, so we don't know what the order says, and that's something that we're kind of always trying to figure out. Why didn't we get served with a specific order when we should have? But that's not us ignoring a court order.
Yeah, no, I understand. I think that's one area. This isn't really a question, but more just for the group. I think that's the one area where I think maybe a technical fix might be a relatively easy lift.
And we're happy to provide technical assistance on any proposals that you might come up with or ideas that you're exploring.
I see Ms. Evans has her hand raised.
I'm on mute. It happens every meeting. Are you done with the presentation, or are you still moving through different sections? Okay.
So the next slide says thank you. So thank you.
Thank you. And thank you, Katie. you've been just great to work with. I appreciate your help and input. And so one of the things that, because we didn't talk about this super specifically, just around like determining risk of harm and like the initial like determination. And the thing that like the recency of disqualification, and this is right out of the 245C16 statute, recency of disqualifying characteristics, recency of discharge from probation. So, the question that it comes up is, for some of the folks we're working with, they got 15 years of probation, right? And so like the fact that, that instead of using either the date of the crime itself or the date of the conviction itself, that y'all use the date of discharge from probation, that can sometimes be just an exorbitant amount of time that a person's been sober, on the right track, doing all of the right things. And so, like, I guess my question for you is, how often are you all using that date as the because we've been seeing a lot of recency as your reason for not giving somebody their set aside? Can you speak to that a little bit?
Or giving someone the set aside. Yeah, so the in terms of the disqualification running from the discharge of probation, that would apply to convictions. If you look, section 15, 245C.15, you have to really navigate it with a fine tooth comb because different types of disqualifications have different look back periods. So like for a disqualification based on an admission, the look back date is the date of the plea. For the conviction, the look back date is the date of discharge from the sentence. For the POE, the look back date is the date of the date of the dismissal for the conduct or for the related charge, or the date of the incident, I believe, whichever is later. So when you're talking, I think what you and I are talking about right now is the conviction related disqualifications. So that's a statutory requirement that the disqualification has to run from the date of discharge of probation, which, as you said, could be 15 years from the date of discharge, which could be 10 years from the date of sentencing, which could be a couple of years from the date of the incident. So we could be talking about many, many years. But that's when the disqualification is required to be issued. When we're looking at risk of harm for whether it's for a potential set aside or a potential expungement objection, we're looking more at when did the conduct occur, because if the risk of harm is related to when the conduct occurred, right? What was the conduct, and who was involved, when did it occur? So that's
Yep. Can you say that first thing you said? Different whats have different look back periods?
Different types of disqualification have different look back periods. So there's a different look back period for a conviction versus an admission versus a POE.
Got it.
Yeah. So the scenario you're talking about. Oh, good. Good. Yeah. So the scenario you're talking about when the DQ runs from the date of discharge, that's for a conviction.
Got it.
Yeah.
How are we doing on time? Do we have time for more questions, or?
I'm okay on time. I don't know, Mr. Vogel, what your
Madam Chair, Mr. Esme, this meeting was scheduled for an hour and a half, but that's essentially arbitrary. We have the Zoom room as long as you and the members want it.
Well, if it's okay with Miss Ryan, I have I think two more.
Sure. Mr. Esme, why don't you go, and then I have a couple questions.
Okay. So I kind of alluded on this before, but I'm interested in what you can talk about in terms of how sort of the discretion of I think the 6 attorneys and in the legal licensing division make their decisions. You had talked about there being some sort of collaborative meetings and sort of feedback amongst each other. I know one of the other members of our group who isn't here today was really interested in sort of what type of kind of, I guess, would frame it as like accountability. Is someone like reviewing these decisions to make sure that they're meeting the agency's goals? Is there anything else that you can talk about kind of generally about the training and experience and how the decision makers are guided?
Yeah, so one thing that I should have clarified a long time ago, we have a background studies legal unit and a licensing legal unit at DHS, so both within the Office of Inspector General Legal Counsel's office. And so the 6 attorneys who are doing the POE reviews are background study attorneys. And then we also have licensing attorneys who do some of the reconsiderations. So the background study attorneys do some reconsiderations and the licensing attorneys do some reconsiderations. So we do have formal training. Obviously we do CLEs, or we put on CLEs, and we also attend CLEs. the attorneys meet. I don't know how much would be appropriate to really disclose in terms of the the individual trainings and experience. But yeah, the attorneys meet very regularly, talk out cases. They are responsible for their own files, so they I know sometimes they review each other's files. Sometimes if they bring a case for discussion, sometimes it's a discussion verbally, sometimes it's looking into the whole file for each other. But we have a high volume, and we're certainly always trying to do high quality work, but also do efficient work.
Is there sort of a, I don't know, quality control like review that like a supervisor, like, I know this is something I see in like prosecutors' offices sometimes, right? That like a prosecutor will tell me, I see what you're saying, why we should be able to make this plea bargain, but I can't because it's going to be reviewed and my boss doesn't like it when we make plea bargains that are that lenient or something like that. Is there any that type of sort of someone's looking over their shoulder or not?
We have training as part of the onboarding process, and ongoing training that we provide for each other. And then we do collaborate across the legal units and within the legal units. Yeah, I hope that answers your question.
Yeah, I mean, I think so. I think I'm hearing that there isn't really, like, there's not like a performance review where we're saying like, I don't know, you didn't give as many set asides as we wanted you to, or we thought you were wrong on this case or that case, that type of thing.
I hear you. So we don't have quotas, if that's what you're asking.
It's not exactly what I'm asking. I'm just trying to figure out what is there.
Yeah. So I mean, all state employees, we have annual performance reviews, which cover a whole scope of how we've performed in various duties over the past year. Obviously, that's something that's very personal for each individual. But no, supervisors don't review every decision that's being made.
Thank you. That's really helpful. And then the other question I have, I think, is a real quick and easy one, going back to like one of the first slides that you had where you were distinguishing between people who are allowed to work during the background study and people who aren't. I'm just curious, for the people who aren't, is there like a different workflow than when your office where those are prioritized and decisions happen quicker or not?
So I manage the background studies legal unit, and that's really a question that would be more for the business unit. So it's something, if you would like an answer on that specifically, I can take it back, but I can't speak personally to that part of the work.
Okay. Thank you. I'll pass to Ms. Dawson.
Thank you. And you kind of started to answer it, but the reconsideration process, you just briefly mentioned, it sounds like there are some attorneys who review, but just the general reconsideration process, who's really doing the majority of that reviews? Is it all attorneys? Is it paralegals? Is it just your standard, somebody who's been trained? What's their background?
They're all attorneys licensed to practice in Minnesota. It's just that some of them are in the background studies legal unit and some of them are in the licensing legal unit. So we have them divided by program type. So, we have them organized basically by who's, how are they regulated and what's the type of program. The goal is to have efficiency as much as possible. And also when people are able to specialize in certain program types, then they're able to do a more meaningful review, knowing what the concerns would be for each program type. And then it allows it leads also to better efficiency. But they're all done by attorneys.
And so just kind of so I understand sort of globally. So like if I have a client, and I'm actually pulling up in a letter a client had just gotten. So there may be somebody who's doing the actual background study investigation, they issue the disqualification letter. When somebody requests a reconsideration, is it going to a different department? So it's not, like, for example, that's one of my issues with maltreatments is they're often reviewed by either the actual person who made the maltreatment finding or just that person's supervisor. So is there some sort of independence here and separation to kind
So
of
the
give,
mal-
it really is another set of eyes.
Yeah. Absolutely, definitely the same person does not make the disqualification decision and the reconsideration decision. The maltreatment decisions, the serious and recurring determination, those are made by professional staff, not attorneys. And then the reconsiderations are all done by attorneys.
And then just out of curiosity, and if you know, and if you don't, might be helpful to just get the information. When a request for reconsideration is made, like for example, you said POEs are found in about 40% of cases. When a request for reconsideration is made, how many of those are, of the words, rescinded or whatever it is versus upheld? Do you know those statistics?
That I would encourage you to make a data request on that. That may be already kind of wrapped into an existing data request. But yeah.
Okay. Those were my questions. Thank you.
You're welcome.
Right.
Any other questions?
Well, if there are no other questions, I know we've been going for a while, so thank you very much, Ms. Ryan. We really appreciate it. This was definitely a long meeting, a lot discussed, and so thank you so much.
You're welcome. Thank you for the invitation to be here.
So just sort of really briefly, and I know we've been going for a while, but I just want to touch really quickly. Originally, we had talked about Mr. Vogel was going to be giving us a presentation on the 2008 report. At the last meeting, Chair Geffen did that. I just want to circle back if there were any questions from that presentation, or if people just even want to table that for the next meeting. I'm fine with that too.
I don't have any questions right now. I mean, I do think as we get closer to our I think our kind of next kind of big workflow goal, right, which is being ready for the report that we have due in a couple months, that's going to be a really good place to start in terms of, I don't think we need, I guess a lot of what the previous group looked at, I think hasn't really changed and is a good place to start when we, when we kind of take the next step to kind of identify areas that could be improved in the statutory scheme.
Makes sense.
I agree with Josh. The other thing, just like you said, a couple months, but it's really due in 5 weeks. And if we want Will to start working on like what that's going to say, we need to give him time to write it up. And so I think, if the framework of it is going to be, recommendations from each subcommittee, like here's what each subcommittee is thinking at this point. We should be thinking, at the next meeting, which is 2 weeks from now or whatever, at getting him what our subcommittee thinks is going to be in there. Because like it's due in 5 weeks.
And I think that's a really good point too, of something I wanted to circle back. If we had kind of planned out our last meeting and this meeting, we'd sort of had an agenda. Unless anybody objects, I think next meeting, it would definitely make sense to, now that we've heard from DHS, we're getting more of the statewide data or the sort of national data from the statutes. I think next meeting might be helpful to start maybe narrowing down and make sort of starting to form what we really want to recommend. So I think that'd be good so that Mr. Vogel has time to do this as well. So if we can kind of start to plan for that for an agenda item for next time. The other thing I wanted to bring up is the disqualification subcommittee. The last meeting, there was a lot of talk about really whether juveniles should be included in the disqualification statute or whether we limit it to, for example, EJJ or permanency or anything of that nature. And so they had asked for a meeting to really discuss sort of the brain development for young individuals and how that can impact juvenile court records, reoffending offenses, the chance to reoffend, things like that. the only thing was, of course, how that may impact our group, especially as we're looking at the POE standard. We've really only been talking about convictions. We haven't really talked about the concept of, does that also include an adjudication? So the disqualification subcommittee was trying to plan something. Would this group have any interest in also participating in that, just to hear to hear the science and the data behind it, to be informed as we're making our decisions?
I would say yes, absolutely. I mean, it seems like an obvious thing to add to the list of factors, the risk of harm factors in the set aside.
Okay. All right, so Chair Geffen and I had emailed about that with Mr. Vogel. So Mr. Vogel, we can, I think, as we're trying to schedule that, try to include this group. And we just meet on different schedules. And so I guess my thought would be, I think we'll also make sure it's recorded. So I think maybe Mr. Vogel, if it's possible to do one of those, the poll deal that you do, maybe that would help, so we can just try to get as many from both groups as possible, would be just my only suggestion.
Certainly, Madam Chair, and I'll coordinate with you and Chair Geffen as I go through scheduling that.
All right, perfect. So then if we all kind of want to plan for next time around, maybe come prepared with sort of what we maybe want to start highlighting, sort of the big picture of what we want to focus on, and then of course narrow it from there. And if it makes sense, to have a share screen up so that we're all we can type these out so we're all looking at the same thing, but try to just come next time prepared with some thoughts, and especially now that we have this additional data as to sort of what makes sense and what we sort of start thinking about what we want to recommend.
Yeah, I got this little ass table in front of my legs. No, I was thinking like with a lot of language I heard in there, like from the federal to the state guidelines, how they're not matching up. They're not matching up. And so it makes it a little difficult. They got to jump through more hoops instead of being aligned. Some kind of, you get where I'm going with that? I'm like, just making it more difficult, it seems like, than making it a lot easier for a person to actually get to where they're going. A lot of people, well, I know at least about 10, 15 people that just say, I already know they on that bullshit or blah, blah, this and that, and just quit, yeah. And it's, so I've been affected by it. So, how I feel about it, and I'm real passionate about it. And because of the process, it wasn't an easy process. So that's why it's totally different to me than others, I guess. That's all. I just wanted to share that.
And I think that's very valuable. And I think that's definitely one thing that I think has come up, is how user-friendly really is this process, and is it working? So I think that's a good starting point for next time, of one of the areas we for sure want to start talking about. All right. Well, if there is nothing else, going once, going twice, we can adjourn. And I think, I know our next one is scheduled. I just don't remember the date. So I'm just double checking here. It looks like it is Monday, February 7th. So plan to see everybody then.
Thanks, everyone.
Thank you.